Okay, Christian, we're live. Good afternoon, everyone. Thank you for joining us. My name is Amelia Ramsey and I'm the Confiscations and Proceeds of Crime Partner at Dugan George. Welcome to those joining us for the first time, and welcome back to those who joined us for our first webinar, which was an overview of the Commonwealth Proceeds of Crime Act. If you did miss it, you can watch the recorded video webinar on our website by searching Dugan George and webinars. That previous webinar and this one will be there, and all the ones in the future will be there, so you can watch them at any time. I'm going to reintroduce our speaker for those who did not watch the previous webinar. We are fortunate enough to have speaking again today, Christian Juebner, King's Counsel. Christian came to the bar in 2004. Before that, he was a partner in the mergers and acquisitions team of Deakins, now Norton Rose Fulbright. Christian took silk in 2022 and has since been recognised by Doyle's in the category Commercial Litigation and Dispute Resolution Senior Counsel Victoria. Whilst Christian principally has a commercial litigation practice, he is also known as an expert in the proceeds of crime litigation. This year, Christian was recognised by Doyle's in the category Leading White-Collar Criminal Law and Regulatory Investigation Barrister in Australia 2024. He is a member of the Confiscation and Proceeds of Crime List Users Group of the Supreme Court of Victoria and of the County Court of Victoria. Last week, Bill Doog, Andrew George and I, along with Christian, travelled to Singapore for the International Bar Association Anti-Corruption Asia Conference. There we met lawyers from around the world working on investigations and representing individuals and corporations in relation to allegations of money laundering. They also act for clients dealing with proceeds of crime litigation, asset seizure and confiscations. In talking with them about their practices, what was consistent was the importance of protecting their clients' interests and assets and ensuring from the first point of contact that the critical issues are addressed. Today, Christian is going to talk to us about the first conference with a client facing restraining orders in confiscations or proceeds of crime litigation. I'll hand over to you, Christian.
Thank you, Amelia. Thank you for arranging for me to speak again, and thank you everybody for joining us on this second seminar. As Amelia said, I'm going to address what you need to turn your mind to, particularly at the first conference. There are really four categories of topics that I think are important. The topics are, firstly, turning your mind to practice issues, that is identifying the interests of persons in restrained property, and I have to say that commonly is an issue of some confusion. Secondly, you've got to identify the timeframes within which you've got to take some positive steps to protect property, and I think you should consider whether or not you ought to seek a stay of the proceedings under the Confiscation Act or Proceeds of Crime Act or whatever proceeds of crime litigation you're dealing with pending the resolution of any pending criminal proceedings. So that's the practice issues. I think there are some ethical issues that you need to consider, and I'll address all these in more detail. The first is you've got to identify conflicts or potential conflicts of interest, and you've got to identify the scope of your retainer, and with that I mean whether it's sensible for you to act in both confiscation proceedings and criminal proceedings. The third topic I think you need to turn your mind to are document issues. That is, to obtain documents relied upon, for example, to obtain the restraining order, to deal with, under the Confiscation Act, property interest declarations, which are unique to the Confiscation Act, not documents you need to trouble yourself with under the Proceeds of Crime Act. I'll come back to those. And I think the last document issue is you've got to start turning your mind to what documents you should collate to try and establish your client's exclusion applications, assuming they'll be made in due course. And the fourth topic that you should be turning your mind to very early on, not necessarily the first conference, but often good at the first conference, is whether or not you can create some sort of a holding pattern. And I addressed this to some extent when I spoke last time about 3 or 4 weeks ago. You should think about living expense applications, variation applications, and funding and legal aid, and most importantly, getting money in trust for your barrister and for solicitors as well. So let's start with the practice issues. Determining who has what interest in restrained property. Why is it important? It's important because every interest holder in restrained property must make their own application for exclusion. That is to say, assume the family home's restrained because, I don't want this to sound sexist, but the husband's behaved in a particular way. It's given rise to charges, and the wife claims an interest in that property as well. Well, they'll both need to make an application for exclusion. It's not enough for one of them to do so because presumably they each have an interest in that property. So it's important right at the start to identify who has what interest in what restrained property. And what I do for my own purposes, I create a table that sets out all of the restrained property, that sets out who claims an interest in it, and then has various comments about how it was acquired, what its current value is, what its encumbrances are. So you effectively get some instructions about each item of property. But coming back to this, this particular issue of identifying the interest, I see lots of errors in this space, and I don't say that critically, but it's fair to say that a lot of people don't understand precisely how interests in property arise. And I'm going to try and give you some common examples where I see mistakes. Now, let's use the most common example where there isn't often a mistake, but it's the family home. If the family home is registered jointly in the name of, again, I don't want to use sexist language, but assume it's husband and wife, then of course each of them will make an application for exclusion. Assume for a moment though the family home is registered only in the name of the husband, and that happens from time to time, or only in the name of the wife if you're dealing with the partner of an accounting firm, or a barrister in most cases. In those instances, if it's the family home, the High Court has effectively said in a case called Property of Cummins and Cummins in 2006, that the presumption is it's jointly owned. And they quoted Professor Scott, and I'll just read a short quote only because I thought it was quite helpful. Where a husband and wife purchase a matrimonial home, each contributing to the purchase price and title is taken in the name of one of them, it may be inferred that it was intended that each of the spouses should have a 1/2 interest in the property regardless of the amounts contributed by them. And that's a recognition that people contribute differently to relationships, and the family home is intended to be owned jointly. So each of them would make an application for exclusion, even if only one of them was listed on title. What about an investment property? If an investment property is registered in the name of a spouse, would the other spouse make an application for exclusion in respect of it? Would that other spouse likely have an interest in it? Chances are they wouldn't have an interest in it. And presumably, if it was an investment property and if things were done properly, then income from the investment property would have been declared to the tax office and expenses would have been put forward as deductions. And the tax office presumably was only told that the particular person on title was the relevant interest holder, and it would be inconsistent for you to put forward a contention that somebody else, the other spouse, for example, who wasn't on title, had an interest in that property. And it's important here, and I'll come back to this later on, not to conflate family law type considerations with the considerations that inform the establishments of interests in property under property law and equitable principles and trusts. What about if assets are owned by a company? Take this example, someone is charged, they're a director, sole director and sole shareholder of company ABC Proprietary Limited. That company owns a warehouse. Who makes the warehouse is restrained on the basis that it's under the effective control of the alleged offender? Who makes the application for exclusion? I have seen instances where the alleged offender has made applications for exclusion, but that's plainly wrong, unless there is some particular instrument by which that interest is conferred, such as a charging clause under a loan agreement or something along those lines. The proper applicant ordinarily would be the company, the registered proprietor, because as a matter of law, a shareholder has no interest, no proprietary interest in the property of a company. If I hold shares in BHP, I only hold shares in BHP. I have no interest in the property of BHP that's owned by the company, and likewise, it would be no different if it's a proprietary company that I use to run my family business. What if there's a discretionary trust? And this happens quite often. People set up family discretionary trusts and accumulate their wealth in family discretionary trusts. And the family discretionary trust has a number of beneficiaries. Often the mum and dads who establish the trust and all their kids, and then by definition all of their relatives and companies controlled by them are all potential beneficiaries under the trust. Who makes the application for exclusion in respect of property owned by a discretionary family trust? The answer is it's the trustee. As a matter of law, beneficiaries have no proprietary interest in the property of a discretionary family trust. The trustee is the proper applicant for exclusion. That's when it's a discretionary trust. What if you've got a corporate trustee that is the trustee of a unit trust? So you've got unit holders, which is a different situation to discretionary objects. In brief, the distinction is that a unit holder is like a shareholder. They have a quantifiable interest that they can enforce, whereas a discretionary trust confers on the beneficiary merely an entitlement to its due administration. So where it's a unit trust, the law says that a unit holder does have an interest in the underlying or proprietary interest in the underlying property of the trust. So theoretically, a unit holder could make application to exclude their proprietary interest from a restraining order if it's restrained. But ordinarily, you would expect that the corporate trustee would also make that application for exclusion in respect of the whole of the trust property. And there are various exceptions that can apply where a trustee doesn't make an application for exclusion, then a beneficiary can, where the trustee fails to make that application. But ordinarily, you would expect the trustee to make the application. What about the purchase of property? Assume two friends get together and they want to buy a development property for $1 million. Assume friend A contributes $200 to the purchase. Friend B contributes $100 to the purchase. That's $300 between them, and they borrow jointly from the bank $700,000. Absent some express agreement about what their interests are, how do you work out what their respective entitlements are? The law says they're presumed to have an entitlement commensurate with their financial contribution. A put in $200,000 and is deemed, or he or she is deemed to have contributed 50% of the joint borrowing. So that's another $350,000, half of 700. So A is deemed to have put in $550,000 of the million, which is 55%, and B is put in the $100,000 plus $350,000, so that comes to $450,000 or 45%. What if they agree, or what if they contribute equally? That is, each puts in $200,000 and they borrow $600,000. The effect is they've each put in $500,000 or deemed to put in $500,000, and they agree that they'll contribute equally to the mortgage, but one of them doesn't live up to that promise and the other makes 80% of the mortgage payments and the other one only 20%. What happens to their percentage interests? The answer is nothing. Their interests never change. The interests are pegged at the time of the acquisition at the 50-50 percentage, pursuant to the High Court's decision in Calverley and Green. But if there was an agreement that one would, or that they would each contribute equally and one failed to live up to that and the other one contributed on their behalf, the person that's contributed more has what's called an equitable lien, that is a charge over the 50% interest of the other to secure repayment of the amount that's paid over and above what was expected of that person. And that's an excludable interest. These are all presumptions, and these presumptions yield to the actual intention of the parties. If there is evidence of actual intention, that will trump any of the rebuttable presumptions. Often there isn't much evidence of actual intention, or it's questionable. People often don't turn their mind to these things at the time they purchase property. But there are examples where parties turn their mind, for example, to the fact that expressly agreed that their respective interests in property should mirror the financial contributions they make, including financial contributions towards the mortgage, so as to overcome the presumption arising from Calverley and Green. And that occurred in a case called Curry and Hamilton, where the parties agreed that they would each share in the property to the extent to which they financially contributed to it. So you work out what the total financial payments were, that is original purchase and all the mortgage payments, and then you work out what percentage was borne by whom. I said I'd come back to the Family Law Act. The Family Law Act comes up often early in the conferences, but it's usually a red herring for this reason. You cannot use the Family Law Act to overcome the consequences of Confiscation Act proceedings or Proceeds of Crime Act proceedings. Specifically, Section 79 capital B of the Family Law Act says if there is a restraining order that's been made, then there is a positive obligation on the party before the family court or the Federal Circuit Court to give notice of that to the parties in the court. Failure to do so is in fact an offence, and under Section 79 capital C, all proceedings under the confiscation legislation, whether state or federal, it wouldn't matter what state because it picks up all the legislation around the country, is stayed. So family law proceedings are stayed if a restraining order is made, and that stay can only be lifted with the consent of the prosecuting authority or the Proceeds of Crime Authority, relevantly in Victoria, the DPP, or Commonwealth, it's the Commissioner of the Australian Federal Police. And I have had some instances where, with the consent of the Proceeds of Crime Authority, we have managed to resolve family law proceedings. And as it's not surprising that in some instances, particularly depending on what the types of charges are, that relationships fall apart and people genuinely seek to separate and wish to unscramble their financial relationships. But absent consent from the Proceeds of Crime Authority, that's not possible under the Family Law Act. So what's clear about interests, which is really the first thing I was talking about, is that they're very much fact dependent, and you should use the first conference or early on in the proceeding to get a clear picture of the financial contributions that people have made and what people's intentions were as to the true beneficial ownership of property. The second issue I think you should turn your mind to very early on the timeframes. In addition, I think Amelia said before that probably only about 20% of my work is proceeds of crime work. The rest is commercial work. And as part of that, I do a lot of work for the LPLC, defending barristers and solicitors in negligence actions. And there have been a number of actions where solicitors have missed deadlines in particularly the Confiscation Act, also one under the Proceeds of Crime Act, and in circumstances that have given rise to quite substantial claims. So you should be familiar, if you're going to practice in this area, with the timeframes. The key timeframes are these. Under the Confiscation Act, firstly, you've got 14 days within which to put in your property interest declaration. That's to be provided to the Proceeds of Crime Squad. Now, there's no drop-dead consequence from a property perspective in failing to do that, although it is in fact an offence not to do it within the 14 days. You've got to file your exclusion application within 30 days. Now, under the Act, if notice of the restraining order has to be given, the 30 days only starts from the date on which notice is given. Otherwise, it starts from the date the restraining order is made. To be safe, always try and file it within 30 days of the date on which the restraining order is made. That way, you won't have a problem. If you're unsure about whether you're within or outside time, make an application for extension of time. Look at the case of DPP and FIN, F-I-N-N. It basically says that you will almost always get an extension of time, but you have to get the extension of time prior to automatic forfeiture occurring. Once automatic forfeiture occurs, you can't get the extension anymore. It's too late. And that was the subject of one of the pieces of litigation that I was involved in against the solicitor. The only exception to the 30-day rule for filing an exclusion application is if it's an unexplained wealth restraining order, then you've got 90 days to file that. Under the Proceeds of Crime Act, or actually before I get to that, under the Confiscation Act, the last thing you need to be aware of is that property will automatically forfeit after a conviction of a Schedule 2 offence. And prior to the expiration of that period, if you haven't got an exclusion application on foot, you've got to put one in, and you'll need to get an extension of time because it'll almost certainly be after that at which that should have been obtained. Under the Proceeds of Crime Act, there's a rare situation. Not many people know of this, I think. That is, there are some instances where you have to make an application for exclusion before the restraining order is made. And that is when you are given notice of an application for a restraining order. That happens rarely, but it happens in those situations where the police or the AFP have seized things such as jewellery, cash, or cars, and then after they're sort of in safe custody, they make the application for it to be restrained under the Proceeds of Crime Act. Now, if you get notice of an application in those circumstances, you must make the application for exclusion before the restraining order is made, failing which you need leave to make the application. You'll probably get leave, but you might as well do what the Act requires of you. Otherwise, the other timeframes are these. Within 28 days of the date of the making of the restraining order, you have to file any revocation application that you wish to make, or file an extension of time for making an application for revocation. There is no fixed time frame under the Proceeds of Crime Act for filing an exclusion application, but be mindful of the fact that if a restraining order has been on foot for 6 months, from that time onwards, the AFP can move for forfeiture order. So my practice is always to ensure that unless you've got some undertaking or some communication that makes it clear that that application won't then be pressed for forfeiture, that you have an application for exclusion on foot when 6 months comes around from the date the restraining order is made. The last critical time frame under the Proceeds of Crime Act is the time for automatic forfeiture to occur. There's a critical distinction, I think I might have mentioned it last time, between, for example, the Confiscation Act in Victoria and the Proceeds of Crime Act of the Commonwealth in the context of automatic forfeiture. Under the Confiscation Act in Victoria, if you make an application for exclusion, time stops running against you. Under the Proceeds of Crime Act, time doesn't stop running, and if the statutory period, which is 6 months from the date of the conviction, expires and you haven't got an extension, which you can get up to a maximum of 15 months, but if it expires, then even if you've got an application for exclusion on foot, then the property will be forfeited. So, as a matter of course, what I do in the matters where I'm briefed is I will arrange for an extension of time application to be filed immediately after conviction, because it's almost impossible to have a case heard and determined so quickly after the time of the conviction. That is, you're not going to get it done within 6 months. Assume you'll need the full 15-month, and there are a number of authorities that effectively say that the court should give you that. And frankly, very rarely has there been any resistance to that. Now, the other topic, as a matter of practice, is considering whether you should seek a stay. Why should you think about the stay? For the obvious reason that it's undesirable for someone who's accused of serious criminal offending to be making affidavits and exposing themselves to cross-examination until the criminal matter's over. There are some stark differences in the way in which the proceeds of crime authorities approach stay applications. It's fair to say that under the Confiscation Act, there's almost no debate about that. If you seek a stay and you've been charged, you'll get that stay, usually by consent. Under the Commonwealth legislation, the AFP often push back against a stay, but there are certainly instances where they've also ultimately agreed to a stay. And of course, Section 319, which provides for stays, is not intended to be a toothless tiger. It's intended to give rise to an evaluated judgment of those circumstances where a stay is appropriate. But you should think about that. Now, the second main topic that I wanted to address this afternoon was the ethical issues. The first ethical issue I mentioned earlier is to identify potential conflicts. This issue arises, conflicts can arise for solicitors in lots of different contexts. Conflicts between the solicitor and the client, that's not really commonly the case in this space. Conflicts between past clients and existing clients, that's also not so relevant. It's more conflicts or potential conflicts between concurrent clients. You'll often have people come in to see you, related family members where their property has been restrained and more than one person in the family is affected by it, and often only one of them is the suspect or alleged offender. Now, that can give rise to situations of conflict. It doesn't have to, but it can, and you need to be mindful of it. And the relevant rule is Rule 11 of the Victorian Legal Professional Uniform Law Australian Solicitors Conduct Rules 2015. A solicitor in a law practice must avoid conflicts between the duties owed to two or more current clients except where permitted by the rule. If a solicitor or a law practice seeks to act for two or more clients in the same or related matters where the client's interests are adverse, and there is a conflict or potential conflict of the duties to act in the best interests of each client, the solicitor or law practice must not act except where permitted by Rule 11.3. 11.3 allows you to act in circumstances of informed consent. But situations where, for example, you can't act and you shouldn't act is where you've got conflicting instructions about the interests in property. Where one potential client says, well, I contributed all the money for that house, it's mine, and someone else says, no, I did. It's obvious you can't act in those circumstances. But more nuanced circumstances are where one applicant or one potential client says, I don't want this to be stayed. I want the exclusion application to be heard and determined ASAP because I want my property back. But the person who's facing charges is saying, no, I don't want that. I want it to be stayed. Now, clearly you can't act for both of those parties either. The third one that I see, and it arises often not at the start, but so wrong to mention in the context of the first conference, but at some subsequent conference, it may be that an offer is made, and this is a topic that you need to be mindful of. Assume this situation: family homes restrained. Husband and wife on title, husband charged with offending, and an offer is made to return to the wife her half interest, but on the basis that the husband's half interest in the property is forfeited. The wife says, I want to do that deal. husband says, I don't want to do that deal, you act for both of them. You've got a problem at that stage. And unless you get the informed consent, you'll have to cease to act for both of them. The second aspect, what I call an ethical issue that you need to turn your mind to early on, overlaps really with this issue of a stay, and that is whether or not, if there isn't going to be a stay, are you going to be acting for both, for an alleged accused in both the criminal proceeding and in the proceeds of crime proceeding? And I know that I've made Amelia feel uncomfortable once or twice when I've asked questions of a client in circumstances where they were facing charges, and I know not to do that now, because of course there's a critical difference between defending a criminal proceeding where a client has a right to do nothing and cause the prosecution to prove them guilty, and a proceeds of crime proceeding where they bear the onus of proof. And if, for example, the proceeds of crime proceeding was to proceed in time prior to the criminal proceeding, you would be required to take clear instructions about a source of funds to acquire assets, the way in which assets were used. Now, if you're defending a money laundering criminal charge, that makes it extremely difficult, if not impossible. I don't think you can do it. If you have a stay of the proceeds of crime proceeding, that allows you then to deal with the criminal proceeding and then come back to the proceeds of crime proceeding, probably subject to one exception, practical exception. It's this: to get a stay under the Proceeds of Crime Act, as I said before, is not easy. One thing that you can offer up in support of an application for a stay is to allow yourself to an examination to be conducted in respect of particular examinees, including the relevant suspects. Now, there's lots of law that says it's very difficult to stay in examination because of the quarantine nature of an examination, but because examinations are coercive, where all of the privileges are abrogated, that is, you can't claim self-incrimination privilege, you can't claim legal professional privilege, it is an arena where you, as the solicitor in the criminal matter, probably don't want to be present. So you might need to hive that part of it off. That's a practical consideration. The third main topic I was going to touch on was the document issues. I think you've got to turn your mind to getting documents together, different categories of documents. The first and obvious ones are you need a full copy of the restraining order. I don't know how many times I get a scanned copy of only half a restraining order, where the second page with the rest of the property is missing. I don't know. But get the full copy of the restraining order, get the full copy of the affidavit in support with the exhibits. You need the exhibits. You're entitled to it. The AFP, as a matter of course, serve it all together. I think the DPP, I'm not sure about the DPP, DPP didn't used to, but maybe they do now. If they don't, you're entitled to ask for it and you will get it. But there are some further documents that you need to also try and get if they're available. That is this: in many of the cases more recently, forensic reports are used already at the time that the restraining order is obtained, and the forensic report is somehow exhibited to the affidavit in support of the application for the restraining order. Now, in order for a forensic expert report to be admissible, all of the documents relied upon by the expert need to be referenced, and the expert report must identify with precision what they've had regard to, failing which the opinion will almost certainly become inadmissible if sought to be used at trial. It's different in the application for the restraining order, but usually these things are prepared on a more wholesome basis. If you get an expert report like that, go to the back of it, look at the schedule of all the documents, because almost certainly it'll refer to endless numbers of bank statements and various other things that your client will find difficult to obtain. Ask for it. You're entitled to get it. So they're the documents you get from the Proceeds of Crime authorities. The next type of document you've got to turn your mind to under the Confiscation Act, this doesn't apply under the Proceeds of Crime Act, is the Property Interest Declaration. It has to be made within 14 days, and I said before, it's an offence not to do so within that short time frame. And that is the first time you have to very seriously give thought to what interest it is that your clients are going to claim in the restrained property. Now, you don't need to go to the extent of saying it's a beneficial interest under a common intention constructive trust. But you need to say A, B, C, whoever it is, claims a beneficial interest in that property. Now, the precise legal basis is a matter that I don't think you need to include in the form, but you certainly need to include in the form the names of the identities of all the persons or companies that claim an interest in the restrained property and the nature or the type of claim they make, whether it's legal or equitable. So that's why you've got to identify the interest early, which we talked about at the start. And then I think the next thing you've got to turn your mind to is getting the key documents that support the flow of funds. Bank statements, tax returns, financial statements for family trusts or family businesses, trust deeds, purchase documentation for houses such as the contract of sale, settlement statement, statement of adjustments, loan applications. They're the sort of common documents that you would try and obtain because they are probably referable to the key types of transactions that you'd have to eventually explain. The last issue or the last topic I wanted to just touch on this afternoon, I think we're going to finish a little bit early, everyone's probably glad about that, is the holding pattern issues. There are really three things you've got to think about early on. The first is whether or not, given the restraining order that's been made, your clients need to make an application for living expenses, both under the Proceeds of Crime Act and under the Confiscation Act and the other legislation around Australia, which exists in every state and territory and differs in various nuanced respects, which makes it interesting. But they all allow applications to be made for reasonable living expenses. But in order for you to make such application, you will need to then explain that there are insufficient unrestrained assets with which you can conduct which you can live. And it requires you to go on oath about those things, including income, expenditure, assets, liabilities. That's the first thing I think is worthwhile raising. The second is whether or not you should make an application for variation of the restraining order, whether any of the property that's restrained should be, for example, sold to reduce the holding costs of things. If they're sold, the net proceeds of sale are usually then paid either to the Asset Confiscation Office in Victoria or to the official trustee for the Commonwealth. Or you might make an application for variation because you have to pay specific debts. For example, someone might have a tax debt, and when that comes around and suddenly your bank account is restrained, you don't have enough money to pay your tax debt, you will need to make that application on behalf of your clients. And the last issue is one of funding. Funding is a vexed issue in this area for this reason. Whilst you can make application for reasonable living expenses and you can get debts paid with the right affidavit material in place, you can never get money released to fund either the criminal case or the confiscation case. That is obviously a policy decision that's been made by the legislature to prevent that from occurring. You can make application for legal aid, and there are provisions in both the Commonwealth Act and the State Act for making applications for legal aid. There was one more thing I think I should have said early on, which I might come back to now, since we've got some time, in relation to the interest in property. And this is something I've also seen more recently and more commonly. Historically, under the Confiscation Act, when there were historical sex allegations and the restraining orders made for compensation purposes, the whole of the property was restrained. But certainly over the last few years, I've seen a shift away from that to only restrain the interest of the alleged offender. So take the classic example family home in joint names of husband and wife. Husband is charged with historical sex offending, and in the past, the whole of the home was restrained. These days, much more commonly, all that's restrained is the husband's interest. So the alleged offender's interest in the property is restrained. What do you do in terms of an exclusion application in that situation? In short, there is no point making an application for exclusion in that situation because the offender themselves can't succeed with it because they can't show that the property might not be required to meet a compensation application. And there's certainly no point making an application for exclusion by a third party because their interest isn't restrained. You can only exclude your interest. In that situation, say, for example, it wasn't accepted that the property was owned in a certain proportion beneficially. What you'd have to do is commence a proceeding, just a civil proceeding seeking a declaration as to the proportionate interests of the relevant persons in the of the proprietors. Say you're acting for the wife, for example, and it wasn't accepted that the wife had a 50% interest, you would commence a proceeding to say that seeking a declaration that she has a 50% interest in the property. Now, if she's on title, I mean, that's not going to happen. But there was a decision, there was a case some years ago, DPP and Arley, for example, where there was a husband and wife. The property was registered in the name of the husband. And Justice Hargrave found that the wife had no interest in that matrimonial property. For this reason, it had been purchased by the husband some years before he met the wife, and there was no evidence that the wife had somehow married him or moved from overseas to Australia on the promise of an interest in that property. And therefore, because family law principles don't come into play, under equitable principles, there was no basis for her to have acquired an interest in that property, even though she had 3 children and her husband was then in custody. And as it turns out, in that case, the property was forfeited, but a compensation payment was made to her, so she had a place to live. That was a bit of a detour back to where I started, but I think that was pretty much all I wanted to say this afternoon. I don't know that there is a facility for questions. If there is, I'm happy to answer them. The other thing I was going to mention is that there is a website, confiscation.com.au, which as of last week has had a revamp. I know it was looking quite tired, but hopefully it's now more informative and the content will be improved over time, and this talk and the other talks will also be accessible there. Thank you.
Thank you, Christian. I agree. Christian's new website is really useful, such a fantastic resource, and I encourage everyone also to go and have a look at it. Thank you, Christian. That was an extremely useful chat, not only on practical steps, like preparing a table of property interests right at the beginning, but also on legal considerations about who must make an application in relation to exclusion of property. I want to thank everyone for attending today. This has been wonderful. Our next one will be held on the 17th of December at the same time, 5 p.m, same place. So please register for our next webinar, and we look forward to seeing you then.
Thank you.
Thanks, Christian.